Hello, everyone, and welcome to another LinkedIn Live. And today we have with us amazing people in this talk a bit about how UAE's data protection can happen, will happen, and what we can do to kind of comply with the law. And we have been helping our clients across, and we also have amazing speakers in the session who have been helping their clients in the region. And today we're gonna go technical, we're gonna go privacy rock solid, and talk about something that people have definitely talked about before, but definitely to add on some things into the current thought process that we have. Okay, perfect. So today we're going to talk about compliance and regulatory requirements under the UAE's data protection law. My name is Akash Singh. I'll be your moderator today. I'm the Chief Privacy Officer and founder of a startup in privacy called Tsaaro, and we also Tsaaro Academy. So these are the two companies that I founded 2 years ago, and 2 years, 3 months, what's the date? The ninth day. I think that's the time that we have spent as an organization alive into the market in GCC, in India, as well as in Europe. We have three offices: India, Bangalore, Gurgaon, as well as Amsterdam, our Dutch office, our European headquarters. Most of the time that I spend is on building privacy frameworks, implementing One Trust Big IDs, and also looking at things like data discovery, and also building courses like CDPOs, teaching CPPEs. That's my job most of the time. But I have amazing speakers in the session for you who are going to help you answer region-wise questions. And I'll start introducing. And Dhanya, would you like to come after this and speak a bit about yourself? So we have with us Dhanya Sri. She's a senior associate at Rasma Legal. And Dhanya.
Thank you, Akash, for this opportunity, and thank you, Tsaaro, for this opportunity. Good evening, everybody. I'll give a brief introduction of myself. My name is Dhanya Sri. I'm a lawyer by profession. Currently, I'm based in Dubai for the last 4 years, and I'm a senior associate, legal associate with Rasma Legal, which is a boutique law firm based in Dubai, and we are more into the fintech, data protection, compliance, regulatory side of legal.
It's great to have you, and I hope people in the session would get great insights from you about the region, about how things work, and how is it different from others. And we have none other than Smriti Pradhan with us. And Smriti is a FIP, by the way, fellow in information privacy, a CDPO. And Smriti is also a senior data privacy consultant, one of the leading consulting companies in UAE. So Smriti, over to you.
Thank you, Akash, and thank you, Tsaaro Academy, for inviting me again as a panelist here. So I'm Smriti Pradhan. I work as a senior data privacy consultant for Paramount Computers, and I've been into the data privacy field for almost more than 6+ years now. And as part of my consulting expertise, I help organizations build the data privacy programs end to end, where we not just help them in setting up the privacy framework, but also I help them in choosing the right technology to operationalize their requirements. Having said that, I'm designated as an FIP by IPP with additional credentials, which Akash has already mentioned, be it CIPP, CIPM, and ISO 27701 lead auditor. It's a very interesting topic today because the law was actually issued last year, and a lot of flux has been going in the region regarding the law. So I'm really looking forward to an insightful session with all the panelists here and with all the professionals who have joined us from the region. Thank you.
It's good to have you, Smriti, on the session. And we have with us Anis Zaidi joining us from Saudi. And he's a cross-industry business analyst and looks at data protection and data privacy, and has been learning with us and has been implementing privacy across. So Anis, over to you for a short introduction.
Thank you, Akash, and thank you, Tsaaro, for inviting us on this panel to discuss UAE data protection laws. Personally, I did my post-graduation in law and I did my MBA in finance also, and I'm in Saudi Arabia for the last 30 years in different job roles and responsibilities. Currently, my group is the Information Technology Group. With them, I am for the last 20 years, and I have seen their business transformation because there was the thread trading earlier, and then they transferred their businesses to information technology. And I was involved in that process. It was beautiful and challenging also. And we expanded to overseas also. So we established offices in Free Zone and in Malaysia Free Zone also, in Labuan. But currently, for the last 2-3 years, I am with their consultancy arm, and we are providing legal and financial consultancy to the clients.
Sure, and I think welcome to the session, and it's great to have you here. A bit about Tsaaro Academy. We are official partners with IOPP, PECB, DSCI, EC Council, and Quality Austria to kind of deliver our courses like CIPP, CIPM, or SOLALI. I think most of the courses in security and privacy are something that we do. We are also featured in Express Computers, CXOs, and the Hinges of the World. A bit about Tsaaro. We are a consulting company. What we do is we help our clients get their privacy work done, get their security work done. I think usually people ask me, what do you do? I think most of the times times it's either a local privacy law that we implement, or most of the times we're doing an ISO 27001. So I think that's kind of the disclaimer before we start this session is speakers do not represent their organizations. I do, by the way, because I'm the founder here, but speakers do not. And people are speaking on their personal behalf. Also, this is not a legal advice. This is a straightforward discussion that is happening only for reference and educational purposes. Okay, so coming to the point straight, all these key provisions of UAE's data protection law and how they impact organizations in UAE. And I would like to start with Smriti. So Smriti, what are these key provisions that we are all talking about?
So, Akash, before I touch upon the key provisions, we have to understand that the concept of privacy is not something new to UAE. There have been sectoral laws which were already touching upon the requirements of personal data protection. But the only difference now is that there is a law which is at a comprehensive federal level, and that is applicable to the organizations who are handling the personal data of the UAE residents. Now, coming to the key provisions, some of the key provisions of the law basically touches upon first thing on the legal basis of processing. So, a lot of focus has been given on the consent-based requirements. So, today, if you want to process personal data, consent is given one of the key priorities as per the law. Following which, the law also focuses on the cross-border data transfer. So, a lot of times we are asked this question that is the law being too strict on the data localization requirements? Well, that's not the case. There are cross-border data transfer requirements that have been placed by the law. And of course, when it comes to establishing the privacy framework, the law focuses upon having privacy impact assessments, maintaining compliance records such as the record of processing activities, and having the right data protection controls in place in order to make sure that any organization today which is handling personal data is protecting the personal data of the users. So these are some of the key provisions, Akash, which has been stated briefly by the law.
I think that is a great point. And I think Dhanya would like to add on to this.
So I would like to start with, because there are still confusion among people, is it actually applicable right now? Should the organization start implementing it? That's one of the key questions that most of our clients come to us with. What do we do? Are we in breach of the regulation already? So as of now, the regulation 45 of 2021, which is the UAE PDPL, Personal Data Protection Law, which is effective from January 2nd. But there's a provision that, the actual implementation, companies can wait until 6 months from the release of the executive implementing regulation, which is not issued yet. So we are all waiting for it. It's a long wait. We all know that. But we are still keenly waiting for the release of the executive regulations. And it is not worthy. And I believe, Akash, we have discussed this before as well. 6 months is a really short time for any organization to set up the framework in place and to get moving. So that's one of the important points.
And I also feel to kind of come out, be a bit honest about the regulation. I'm talking about a general privacy regulation. And a lot of times, our clients come and say, hey, Akash, we are in a hurry to kind of implement and get compliant to a privacy regulation, any regulation in the world, right? Unfortunately, we are missing out in the long term is privacy law is not a short-term strategy, because complying to a privacy law without a data governance strategy, without making sure that all over the infrastructure we have consent and the frameworks implemented, I think it's near to impossible to even say that we are complying to it. Most of the organizations, I feel it very sad that there are some organizations who are just doing gap assessments on the basis of policies and giving a result out of it. And that is something that is the current state of the industry across the world. The real problem is when you say that you really comply to a law, and then that answer is never, because a journey of privacy law is a journey, right? And you're taking a journey and you can get compliant to some score, let's say 80%, 70%, depending on the parameters that are set up with the organization. But 100%, I think I've never seen that compliance hitting 100%. But I definitely feel that if we do not think about data discovery, do not think about ROPAs, do not think about privacy impact assessment and continuous upgradation of our assessments, I feel it becomes very difficult to comply with the law. Again, coming to the point as next question, what are the key compliance and regulatory requirements under UAE's data protection law? And again, I think I would probably ask Smriti again about this. I know she's a deep expert in UAE's data protection law. So Smriti, what's your take on the compliance and regulatory requirements? And I get it that sectoral requirements are there, but kind of taking on case the UAE data protection law.
So when it comes to UAE data protection law, the reference of the law has always been the international laws such as GDPR. Now, when it comes to the key compliance and regulatory requirements, I think how this law differs from the other laws in the region as well as from the international laws. Legitimate interest as a legal basis of processing is not recognized under the law. So any organization today which is having processes based on legitimate interest, they need to look for alternatives. And like I mentioned in the previous slide, the focus has been more towards the consent as a legal basis of processing. Having said that, the other requirement requirements cater to the data subject rights, which are very similar to the laws which we have seen internationally. So there are 6 to 7 rights which have been given to data subjects when it comes to accessing their information, rectifying the information, or deleting the information. So these are some of the rights which have been given to the residents of UAE, which will actually empower them to make sure that their data is protected by the organization. The third requirement is around maintaining something called as a record of processing activity. So any organization today which is handling personal data or processing personal data, they need to make sure the life cycle of the entire personal data management is captured, and this is something which is required by the regulation. The other requirements, of course, once you identify what is the digital footprint within your organization. So first thing for any organization as part of a regulatory requirement is to go forward with a data mapping exercise where you make sure you understand what is the footprint of personal data within your organization, and then you gauge the privacy risk as part of privacy impact assessment, which is another requirement stated by the law. So these are some of the key compliance requirements. And coming to the data localization part, like I mentioned, cross-border transfers have been recognized under the law, and adequacy is something which the law is recognizing as part of it.
Anis, would you like to add on to this? If you see that there are some regulatory or
Yes, Akash, there is very important thing in overall this data protection policy, the data protection policy and privacy and governance is the training of the employees. Because what we have seen, the employee in general, they are not aware about it. So this is very important. This organization must provide regular training to the employees for the data protection and data privacy laws and make sure that everybody is on board. This is very, very important, I think.
I think that's the great point pointed through. So I think we have a question. Mr. Pawan has asked a very important question. I think I would probably point out to Dhanya. So Dhanya, do you think that data localization allows copy of data to be kept outside of UAE?
Yes, I believe so, but we still have to wait for the executive regulations to understand more on this aspect, because the current regulatory framework that was issued, it's just a framework structure. So the actual implementation part, I can say that this current regulation is extraterritorial in application. So ideally it should be, but then we have to wait for the executive regulation to understand more as to how practically we can implement the whole process.
Sure, Dhanya. I think Smriti would like to and Anis would like to add on to this.
So I agree with Tanya actually. So if he's saying that data localization allows a copy of data to be, yes, according to the framework which has been set right now, the thing is, there's a pattern which is being followed in UAE currently. The regulators, they are not against business innovation. And you know that today a lot of innovation happens because of the data which is being transferred. So there is a requirement where privacy and innovation is balanced, and that's where this requirement is not very strict, Akash, at this point of time. But yes, we want to wait for the executive regulations to make sure that this aspect is also addressed.
Well, for many things, Akash, we have to wait for these regulations which are still awaited. There are many areas where we have to wait and see that how it moves.
I think we have a counter question to this. Pawan has asked, what is the adequacy you're referring to, Smriti?
So there is a concept in data privacy that cross-border data transfer will happen if the country recognizes another country as an adequate country. It means the country to which the data is being transferred, they are very strong in their laws, in their privacy requirements, and they do give a lot of importance to data protection. So that is the adequacy I'm talking about. And this list will actually be released by the Data Office of UAE when they recognize the requirement of cross-border data transfer. So that's the concept of adequacy.
Pawan, I hope you have got your answer about what is adequacy. I think Swati has asked another question, and I am loving these questions because the real questions of the people are to be answered, and that makes a lot of sense. Question is, what kind of consent is being recognized? Is it implicit? Is it explicit? Any one of you would like to take it? So what type of consent is being recognized in this? And I know the final draft is to come, but in the last draft, what did you see?
So the alignment of the consent is mostly towards explicit, and the reason behind that is because they want the users to make sure that they are aware of what data they are consenting to. So it is explicit as of now, but yes, further clarity will be coming in executive regulation. But as of now, the alignment is mostly towards the explicit consent.
Okay, and Tanya and Anis, would you like to add on to this?
I would like to add one point. So there might be some circumstances where the consent wouldn't be required. So for example, for public interest or for any particular reason, judicial interest. So we are yet to understand more. We are going to wait for the executive regulations, but there's a chance that under certain circumstances, exceptional circumstances, a consent wouldn't be required.
Yes, for the now, it should be very explicit and unambiguous and informed and specific. There is no concept of deemed consent so far, except as Dania has said that maybe there are some situations where we can say. Otherwise, for now, it's no explicit consent.
Yeah.
I agree.
So Anis would like to take this up as to what are the non-compliance consequences?
If you not comply with these provisions, there are fines. As in Saudi, they have put some imprisonment also and reputational damage also, and problems in your business operations. So these are the direct and indirect consequences we have to face if we are not going to follow these regulations.
Yeah. So, Dhanya, would you also like to add on some numbers to the fines that the last time came?
So, Akash, in this regard, the regulation haven't explicitly stated any fines or any penalties as such, but we are expecting, obviously, considering how serious data breaches are, how important data is for the economy and the business and the people. So, in the executive regulation, yes, we are expecting some huge numbers, to be honest.
Sure, Dhanya. I think Kriti has asked me in this session that what are the basic documentations we have to add on in our privacy policy, in our compliance? I'll personally take that question up, by the way. If you're already having the right set of policies, the right infrastructure. Let's say an organization complies with GDPR. Now, what do they have to do? That's the question. What do they have to do? Looking at what are the changes that we have to do in terms of data subject rights and the principles of the law, how DSRs will be responded to, and also in terms of our privacy risks, because privacy risks are also identified on the basis of what rights had to be given and what principles have to be followed as a law. Those things, when they change, the PIA comes out with a different risk matrix. So I feel we really have to look into it. And I also feel that privacy professionals across the globe may not be skilled enough to understand this problem as well. I'm saying that industry itself is growing. So the problem has to be solved from day one, and education is one of the major things, not just for an organization, but also for the privacy professionals who are kind of doing this for the organizations. So coming to the next question, Smriti, you and I were having this discussion, probably this question came up. Does the data transfer between Emirates come under adequacy? But I also have a question, and I will add on to this question because I feel Emirates will definitely be, all the states will always have an adequacy anyways, the data will get transferred.
Right.
But the question is, what will happen to a free zone? I think that's a better question, right, Smriti?
Yes. Because free zones, they already have their set of.
Exactly. So let's dissect this question logically, Akash. So even if you look at the UAE PDPL, there is a reason why they have exempted free zones from it. Because free zones already have that kind of a data protection regime that makes sure that your data is protected. Now DIFC and ADGM, they have very solid data protection laws. Now let's say the data gets transferred from free zone to mainland. It will still fall under adequacy because the mainland laws will be driven by UAE PDPL. So that's my answer to it. But yeah, that's the way to go about it.
Sure. Also, another important question that we have is, what are the DPO requirements? Is it a mandatory DPO requirement? Is it not a mandatory DPO requirement? And Dhanya, would you like to take that question up?
So yes, there are certain circumstances where the appointment of DPO is mandatory. For example, if you're processing large volumes of data, or if you're processing sensitive data, if there are specific kind of data that requires more protection. So these are circumstances, even though the numbers are not prescribed as to what is the number of data subjects to be included, but these are three conditions that they have mentioned in the regulation as of now, where you need to have a mandatory DPO appointed. And it's to be noted that an employee can act as a DPO under the regulations as of now.
Yeah, and Smriti and Anis, would you like to add on to this?
Yes, there are some other situations also. For example, if you are making profiling, automatic profiling, then also it's very necessary to have this DPO on board who will be consulted, and he will be overall responsible for this implementation of all these regulations in the company.
Just want to add on to Anis's point, Hassan has asked this question that which all companies will be required to hire a DPO, which is rightly answered by Dhanya, and he's also saying that especially since the availability of the resources is scarce. So we have to understand one thing, that this is a requirement which is driven by law. Even if the resources are scarce, companies will be bounded to hire a DPO. But here I would like to focus on one thing. So there is a clause in the law which is talking about exemption of a company under UAE PDPL. Now that exemption will depend upon various variables. Variables will be what is the kind of processing the company is involved in, what are the high risk kind of processes the company is involved in, and also what is the number of data subjects the company is catering to. So let's say you are a company with a very small number of employees and you're also not involved in very high risk processing. In that case, you don't need to hire a DPO because UAE PDPL in itself will be exempted from the organization. So of course, I understand this question because this question is coming from that mindset that it might lead to compliance cost or a compliance burden for the organization.
I think that's a great answer, Smriti. I hope the person who asked it got their answer. I think Ashish has asked, when comparing the UAE data PDPL with GDPR in principle, except for legitimate interest, do we have any major changes proposed under UAE PDPL? So Smriti and Dhanya and Anis would like to take that question question.
So, Ashish, just to answer your question, honestly, if you ask me, this is one of the major changes which we are seeing, because once you don't recognize legitimate interest as a legal basis of processing, you will alternatively fall onto other legal basis which has been provided under the law. And of course, it is going to become big tricky for the organizations, because already the processes which are under this legal basis, those processes need to look for an alternative route. Now, having said that, what are the other major changes? There are no major changes, but yes, there are changes regarding the cross-border data transfer requirements, or you talk about the data subjects right. So there are minor changes regarding those requirements, but this is one of the major change, Ashish.
I think Hassan has asked, is it better to follow an NIST approach in terms of clarity?
Yes.
And I honestly feel like, in terms of an approach, I feel an approach has to be aligned to what type of data you are taking and what type of privacy risks may arise in your organization. When we are working at our clients, the first thing that we do is we trying to figure out what type of risks are there, which industry you are in, and then build out that framework and then go about it. NIST, I feel, is good, but I also think that when we look at a GDPR framework or base out our frameworks on GDPR, makes more sense to kind of make sure that we're also complying to the law. I think that is also an approach that you can think about, not just think about that NIST is the only solution. I get it, for a US organization, NIST makes 100% sense, but I think somewhere down the line, we have to assess what makes sense and then take the right decision, because policy making is the first step, and the first step is easy. The problem starts when you start telling your organization teams that, hey, this is a policy, did you follow it? What is the retention schedule on the data that you just took? And I have been in these discussions since all my life, so I feel like it's not just about building that policy, it's not just about building that program, it also is about things that make sense to the person on whom this law is going to be implemented. I'm not talking about a customer, I'm talking about the inside marketing team, your sales team, your processing team, your analytics team, because they will ask you all the right questions, because they are getting affected by this and their work is going to change by this. Let's go next and take questions. Saira has asked, does DPO need to be an independent constitution to the company? I feel like, I think I would let it be on Smriti. So Smriti, what is the independence of DPO that you see in UAE region?
So I personally recommend all my customers that yes, it should be an independent constitution within the company. Then we have to not be any contrast, because the moment, so let's say you want to put forward with a role where you, for a person who's handling both information security and privacy, there might be areas where you will see conflict of interest. So yes, it's always recommended to have an independent institution within the company itself. So only from a
And I
recommendation
also
perspective,
feel,
this is something which I would
yeah,
like to
also,
add.
also I feel like when we talk about a DPO, the job of a DPO is to say no to a few things. And when you are saying to a few
Exactly.
things, then if you are the same person who's kind of doing things, then think about it. It doesn't make sense. Even if the law doesn't say it, or if you have to comply to a law, I think independence is mandatory. And also what I've seen is, I know a lot of CISOs and legal heads are listening to us right now. So what I've seen is the session and the DPO role kind of gets divided. And I know DPOs all across the globe, and I know how things have been working for my clients, and I have been teaching them somewhere down the line. As Smriti said, what I have also been telling them is a CISO kind of takes the implementation roadmap, and the legal head kind of takes up the legal DPO function. So I think that is also a good, very fair division till you get mature enough to have a DPO, because privacy is also a question of maturity. It's not just a question of compliance, it's also a question of maturity and what do you do and what do you get out of it. So a lot of underlying questions to kind of answer as an organization before come back. And so Mr. Hassan has asked another question, and I will point it out to Dhanya now. How can we take advantage of standards such as ISO 27701 to exhibit compliance to international privacy practices? So yeah, Dhanya, what do you?
See, Akash and Hassan, one of the major issues that I've seen my clients face is that in UAE, especially, like there are people from different jurisdictions. They're like inter-jurisdictional issues. They process data from other places, and they have to make sure like they are complying with other regulations as well, not only UAE regulations at some point. So I believe when it comes to the common standards, international standards, we should keep in mind to adapt something that's more stringent, so that we will always have the compliance in place. We are always compliant no matter which jurisdiction we are processing the data from. So that's one thing that I can recommend on this.
That's a very fair recommendation.
I'll just add on to Tanya's point. So there is also an article in GDPR which talks about certification mechanism. Now, Mohammed, if you go forward with ISO 27701 compliance, somehow you're also making sure that you are in compliance with that article number, because here you're also getting certified. Your organization is also getting certified, and you're making sure that you are in alignment with the global law. So this is where you can take advantage, because sometimes people want to see what is your credibility in terms of the data protection framework which you are setting up in your organization. And this provides you a very good tool to certify your organization and make sure that you are in compliance with the global laws. So that's one
Yeah.
of the biggest advantages of 27701, Mohammed.
Yeah, I would also like to end our session. Guys, if you have any questions, feel free to reach out to us speakers as well. It's not a problem. Most of us are consultants here. So somewhere down the line, we will solve that problem. And by the way, I just wanted to say that Dhanya, Smriti, and Anis, it's great to have you on board in the session. And I'm just loving this conversation. And you guys are amazing speakers. And you guys have been answering it so well. I think somewhere down the line, I just want to thank you. And I want to thank everyone who's listening to us. Thank you for sparing your time, coming on board, asking that right question. It's a privilege to host you in Tsaaro's session. And guys, Dhanya, Smriti, and you would like to say thank you to everyone.
Thank you.
Thank you, everyone. Thank
Yes,
you.
hope
Thank
it
you
was
everyone
helpful.
for joining.
Very good.
Yeah.
Thank you. Thank you.